Taxpayer Services, DGTS, has always been in the forefront in taking the important policy framework of the Government of India in taxation matters directly to the taxpayers' doorsteps. In this regard, DGTS has been regularly conducting webinars and outreach programs on various subjects that are of immediate relevance, interest, or importance to the trade, importers, and exporters. Today's webinar on intellectual property rights, implication in GST, which is being conducted in association with CAI, Southern India Regional Council of the Institute of Chartered Accountants of India, AP Chambers of Commerce and Industry Federation, All India Federation of Tax Practitioners South Zone, is yet another initiative in our endeavor to handhold the taxpayer in taxation matters and to further increasing the ease of doing business. I am Nedimaran, Deputy Director, DGTS Chennai, your moderator for the today's session. It is informed that the mic is muted and the camera is disabled for all the participants other than the speakers in the session. Mic is muted to avoid any unintended audio interruptions so that the speaker is audible to all, and camera is disabled to avoid bandwidth related issues and to have an interruption-free session. However, the chat box is enabled for all and the participants can register their questions, queries, doubts in the chat box during the course of the session. During the Q&A session that follows the main presentation, these queries, doubts that are registered in the chat box will be taken up and answered, clarified by the topic speaker. It is requested that the question, queries, doubts be restricted only to the topic of today's webinar. I repeat, it is requested that the questions, queries, doubts be restricted only to the topic of today's webinar. Our Additional Director General DGTS Chennai, Shri Rajiv Ranjan IRS, is unable to join today due to some health issues. So, may I now call upon the member Economic Affairs and Advisory Panel, CAA, Shri Sumit Kedia, to deliver the guest letters, please. Sir, over to you, sir. Mr. Sumit, sir.
Yes, sir. Am I audible? Sir, am I audible?
Yes, sir. Yes, sir. You are audible, sir.
Right, sir. Thank you. Shri Rajiv Ranjan ji, ADG, DGTS, Chennai Zone. I understand he is unwell, so wishing sir a speedy recovery. Ms. CA AB Geeta ji, Chairperson SIRC of ICI. Shri Ramakrishnan ji, Vice Chairman Taxation Committee, AP Chambers. Shri G. Bhaskar, Chairman AIFTP Zone, Southern Zone. The respected speaker and the participants. A very good afternoon to all of you. So the topic of IPR, intellectual property rights, has been in dispute from a very, very long time. Right from the regime of VAT, service tax, this subject has been a matter of litigation, and we've had various judgments in high courts, Supreme Courts, whether I talk about TCS, Infosys, etc., where it was deliberated as IPR is goods or service. Because in the earlier regime, service tax was demanded on IPR, simultaneously respective VAT was also demanded on IPR. Even in service tax, we had Section 66E of Finance Act 1994, which defined these are declared services, in which IPR also had an entry. And in certain cases, both service tax and VAT used to get demanded, stating IPR is a goods or IPR is a service. In the service tax law, even IPR was defined. In GST law, we do not have the definition of IPR, but generally IPR includes trademark, patent, copyrights, etc. In GST law, in Schedule 2, they have given an entry of IPR where they have said temporary transfer or permitting use of IPR is a service. They have not told anything about permanent transfer. So still in GST also there are certain areas where there are scope of litigations. We have a couple of advanced rulings also on this topic, where certain areas it has been deliberated whether IPR in certain cases will be goods or service. So I think I'm sure the able speaker will be able to throw light on when it can be treated as goods, when service, what judgments we can rely on, and what are the rates by which there can be a significant difference if I treat a transaction as goods or a service. Even when we talk about import and export of IPR transaction, international IPR, that can have a far-reaching impact. Even IPR, we have to check for RCM implications. When we talk about cross-border transactions, there can be impact of even RCM. So I think this is a very apt topic because those companies who do particular transactions in IPR, like transfer of copyrights or a permanent transfer of patents, you will see a lot of medical companies, they sell IPR patents for huge values. So this topic can have a far-reaching impact if there is any particular transactions on IPR. So I think it's a very appropriate topic selected by DGTS, and I'm sure the speaker will throw a lot of light on this topic, which will be helpful to all the participants. Thank you, sir. Over to you.
Thank you, sir. Now, may I now call upon Mrs. C.A.A.B. Geeta, Chairperson, Southern India Regional Council of the Institute of Chartered Accountants of India, to deliver the guest letters, please. Madam, over to you, ma'am. And Geeta, ma'am, are you there?
Yeah, I'm here, but
Yes,
one
ma'am.
second, sir. My video is not yet switched on. I'm visible? Hello?
Yes, ma'am. You are audible, ma'am.
Audible. Whether I am visible?
No.
Okay. Okay, is it? Can I continue like
Now
this?
just it
Some
clicked,
problem
actually.
is there in my video, I guess. Hello?
Yes, ma'am.
Sorry, sir, can I continue like this without video? I think some problem is there in my video.
Please continue, ma'am.
Yes, yes. Good evening, everyone. Distinguished guests. Sumit Kedia, member Economic Affairs Advisory Panel, CII, South Indian Southern Region, and Mr. Ramakrishna Sangu, Vice Chairman, Taxation Committee, AP Chambers, and G. Bhaskar, AFTP, Chairman, Southern Region, and distinguished speakers, MG Kodanraman sir, Assistant Commissioner retired, and we missed yet another speaker, Rajiv Ranjan sir, hoping for his early recovery. And my dear esteemed members and participants gathered today here virtually, happy afternoon to one and all. So it's an honor to be here at this event where we are discussing about a topic that is significant for our profession, not only for our professional community, but also in a broader impact on the economy and growth of our nation. I would like to extend a warm welcome to everyone, and especially to our distinguished speakers whose contribution to this field of intellectual property, which is a very special area of interest, because everyone, most of the people, they don't practice in this area. Very few who are very much interested in this area, they only have expertise and practice in this particular area. Really, the knowledge, the sharing of knowledge from them is invaluable. And today, when we focus on the implications of GST in relation to intellectual property, and to GST since its inception has been a revolutionary step in simplifying India's intellectual system, promoting transparency and boosting economic growth. And by incorporating a wide range of services under its ambit, GST has streamlined the tax structure, facilitating ease of business and enhancing compliances. The recent inclusion of IP-related transactions in GST itself is it marks a significant development, indicating the evolution and adaptability of our taxation system. And when it comes to intellectual property, it plays a pivotal role in our modern economy, driving innovation, creativity, and competitiveness. Whether it's a copyright or trademark, patents or designs, these assets represent the hard work and creativity of our individuals and organizations. So with this GST's inclusions of IPs, we are witnessing a more unified approach of taxing these assets, which will undoubtedly contribute to the end country's GDP by fostering a conducive environment for innovation and business expansion. So it's a crucial moment for us to understand how this GST impacts the intellectual property. The tax implication it can affect licensing, royalty payments, technology transfers, and a host of other transactions involving IP. So this kind of joint programs aims to shed light on these complexities, offering insights into compliances, best practices, and future trends. So our esteemed speaker of today's speaker, Kodendram sir, uh, who we know him as extensive with his extensive writings on IP in our KCA newsletter in Karnataka, because he is known for his series of writings on IP education series, and his invaluable his insights, which will be instrumental in navigating the complexities of the GST as it relates to intellectual property. When I was there in KCA, we have done a couple of joint programs with AFTP, which was well appreciated and received by members. Earlier we have done a couple of programs with the CAI too, but I guess this is the first time jointly we are doing this joint program with the AP Chamber of Commerce. I think it's a privilege that too, in Chamber of Commerce at the helm of affairs, we have our own member, Mr. Ramakrishna Sanghu, who was closely associated with us when I was the chairman of Bangalore branch. So seeing him as a vice chairman of Chamber of AP Chambers is really a great moment for us. So as we move forward, it's imperative to continue fostering collaborative events like this one, which bring together professionals from different backgrounds. So by working together, we can ensure that our members are well informed, our businesses are compliant, and our economy continues to thrive. So before concluding, I want to thank the co-organizers who put their hard work for this event, to make this event a grand success. So I hope that we wish to have more and more joint programs like this, where we can create a platform for sharing our knowledge, fostering relationships, and driving progress. Thank you all for your participation. I look forward to a productive and insightful session ahead. Thank you, one and all.
Thank you so much, ma'am, for the kind words of appreciation. Your suggestions also will be well taken. Now, may I now call upon Mr. Ramakrishna Sanghu, Vice Chairman, Taxation Committee, AP Chambers of Commerce and Industry Federation, Andhra Pradesh, to deliver the guest address, please. Over to you, sir.
Namaste, everyone. Good evening. I'm very glad that I am part of this particular seminar and seeing Sri Kodendramji on the screen. In this today's session would be I'm convinced that it will be a very important topic, particularly for the reason that levy of indirect taxes on intellectual properties from the previous regime of VAT and service tax is said to be complicated, maybe for the reason that it is inherent nature of invisibility, intangibility, and simultaneous use by many people, like franchisee of a McDonald's for spread across the country kind of transactions. And we all know IPR includes like patents, trademarks, designs, copyrights, etc. And I feel that in the case of commercial transactions relating to IPRs, one has to see whether it is a supply as per section 7. Once it is a supply, when we use the word supply, you may have to refer to schedule 1. And then once you determine whether it is a supply, then you may have to refer to schedule 2 and see whether it is a supply of goods or supply of services. As para 5C, as pointed by our dear friend Sumit Kedia, that para 5C of schedule 2 categorically says that temporary transfer or permitting the use or enjoyment of intellectual property rights shall be deemed to be a service, and read with 452P of notification 1/17 CTR, that is the goods prescribing the rates of tax on goods, says that permanent transfer of intellectual property shall be goods and prescribing the rate of tax of 18%. Both their service rate and the goods rate is set to be 18% on the, and it is more important for these two reading, because to understand when a supply of intellectual property rights will be treated as a supply of goods and when it will be a supply of services. And having said that, then the question comes in some cases like 13/17 dealing about reverse charge mechanism with respect to music composers, photographers providing services to music company or producers, where the producers are liable to pay tax, and authors of the books where the publishers are liable to pay tax in terms of reverse charge mechanism. And particularly when you're importing services from outside India, the person importing the IPR is the person who is liable to pay tax under the IGST notification under reverse charge mechanism. And to my knowledge, there is a clarification or notification in 2018 whereby CBIC clarified when the IPR values like royalty, technical fees, license fees, etc. was included in the customs valuation, then the same shall not be liable to again GST on the same value, as it may amount to double taxation. And finally, I would like also feel important that determination of place of supply of services is one more important area, both under section 12 of the IGST Act and 13 of the IGST Act. And fortunately or unfortunately, in both the cases, it is the location of the recipient of the service is the place of supply as far as intellectual property rights are concerned. And I know, I strongly believe the Kodandram sir will highlight all the provisions and relevant case laws to better understanding with this small background of the whatever little knowledge we have. And we thank you very much, sir, and looking forward for your session, sir. Thank you so much from Andhra Pradesh Chamber of Commerce.
Thank you so much, sir.
Thank you.
Yes, I have been informed that Mr. G. Bhaskar, Chairman, All India Federation of Tax Practices South Zone, is unable to attend this meeting because he has some preoccupations in the Midafia High Court. Now, we have come to the main part of the program today. To make the topic presentation, we have with us a very distinguished person, a man of varied interest, Shri M.G. Kodanram IRS Assistant Commissioner, retired Bangalore. He has a rich experience in the department and is a master trainer of GST for nursing CBIC. He is a recipient of Sanman Award from the department. He is also the member of GST Committee, FKCCI, member of Expert Group on GST, Fiscal Policy Institute, Government of Karnataka, advisor and resource person for KSCST, Government of Karnataka, CIPAM, Government of India, VTPC, Government of Karnataka, and founder member, FDPPI. He also authored several books on GST, which is published by Karnataka Law Journal Publications. May I now call upon Shri M.G. Kodanram sir to make the presentation, please. Sir, over to you, sir.
Good afternoon, everyone.
Good afternoon, sir.
I think I am visible properly now. Yes. Am I audible?
Yes, sir.
Yeah. I will upload my PPT and then resume my talk. Whether the PPT is visible?
Visible, sir.
Yeah, right. Friends, I am extremely happy to be in the midst of youngsters. You people have been very benevolent to give me opportunities time and again to share my knowledge. I keep on saying, when an elderly is burnt, the whole library is lost. So you people are making use of some knowledge we have, for which I feel more privileged and happy to submit before you. Today we are looking into IP rights as existing in the GST law. I will not be dwelling on the past more, but I will certainly dwell to make you what is an IP, because there may be some new people who have joined. So I will start my talk with certain overview of IP, whether it is a property like any other property, or just because it's intangible, how it should be measured in the tangible aspects, expressions, we will try to know. Secondly, unlike other types of supplies, here various stages of supplies do appear. I'll be explaining you each stage. I have divided this supply in the IP itself as up to the time of grant. So unless these rights are given to you, they are not a property belonging to you. So at that stage, how things move, we will look into the supply aspect of it individually. The second part, Once you are the owner of that property, how do you deal with that property? That is, whether you rent it, license it, or assign it, sell it, we will try to understand that concept. Once this major second part of the transaction is over, comes in where this IP are expressed in the form of tangible items. So those also are very important. So it is structured in such a way that I will take you through the part 1, part 2, part 3 in a systematic way. Later on, we will move for imports, as my friend was telling rightly, or the complications there. We will try to look into the custom aspect a bit. And lastly, what are the other related items we look at? And small slide on the border measures the customs is taking. And border measures, I'm very, very happy because for my department as well as CPAM, I have written the manual for them. And till 2007 enforcement rule came, I was only had certain basic ideas of IPR. In 2000, when customs law was changed to include enforcement rules, I joined the National Law School. From there, I started my journey. Today, when I look back, I have to thank my professor, Mr. Ramakrishna, who has taken me such a long way. I never thought, starting so late, I can bloom to this level, for which I remain grateful. Coming back today, intellectual property. The presentation is what is IPR? What are the types of IPR? This may be a repetition who people are having knowledge of IPR. Please bear with us. Then we will look into the supply aspects. In that, possible scenarios, those 3 scenarios, I'll try to explain. During granting, licensing and assigning, the second stage. IP in goods, IP in services, rates, how it should be decided, and challenges in valuation with case study and certain aspects of import. Now, whether it is a property, we always say intellectual property is intangible, owned, legally protected by a company from outside use or implementation. When I say this, most of the people will get confused. Sir, what is this property? I tell them, always don't be under the impression property means a tangible item. I tell them this house is yours because under law, the rights are vested in you. This car is yours because under law of the land, it has been recognized under your name and it is registered under your name. The land belongs to you because it is written there. This mobile laptop belongs to me because under Contract Act, it has recognized me as the owner. In other words, property means the bundle of rights. Kindly note, the rights you have. That is what makes a property is all about. If you look into the real name of property, how this property gets generated. Let us take a very simple example of the graphite ore. If graphite were not to be thought of in a better way by a interesting guy or a creative guy, today it would have been an ore lying in the earth. That ore has become a diamond, and from diamond we have used in or cutting for industrial things. There is 2 ways it has developed. There is a material contribution, there is an intellectual contribution. Take any item for that matter. There are 2 streams which has to add value to that. One is the material, the thing itself. Second, the thing to perform. There, technologically, somebody should creatively think of and bring that out. To take a recent case of our COVID vaccines, if we were to docile without inventing, it would not have been possible. A lot of clinical trials were done. They have spent day and nights without any this one and spent crores of rupees for doing research to find out that specific vaccine which can act upon. And when they were about to sell, if we don't recognize their rights, of that knowledge, it doesn't help. So there, government gives exclusive rights to them so that it protects their intellectual output, intellectual knowledge. Thereby, anybody who wants to do it have to pay that royalty or whatever, if it is a license fee, and then manufacture. Means it is a recognition given through legal rights. So exclusive rights given to the person over creation of their mind. I hope you agree that it is a creative and a right is there, that whether it's still a property, sir, just because rights are there, we will look into that. So for the time being, you can understand IP as a legal right. It is intangible potential asset in itself, but it gets the value only when it is used in a tangible goods. For example, the vaccine gets the value when it is made into a vaccine and used, utility is there, then only it becomes. You take any item, for example, a film being produced, the lyricist will write his song. Unless the singer sings it, it doesn't get that. Then that singer is further music direction is done, and then it is made into film. You can appreciate the development of both the mind as well as the material. By the time the film comes and shown to you, it is in the tangible form. This is how it comes. We will try to get it into that. Why this is given? It is given so as to provide them a limited monopoly, not an open monopoly, limited monopoly for certain time, so that they will get back what they have invested in that creation. That is very, very important. Sir, is it a positive thing? No, it is a negative right. If somebody tries to do, he can sue against you and take relief, take damages, claim damages. For example, a trade name, if you use and try to pass it off, he can sue you and see that your materials having that fake trade name can be seized. So this is where these are rights vested by law on the creators, but for a limited time. Why for a limited time? If you give it the monopoly for a longer time, the public will suffer. In what way public rights will get into better? For example, a medicine is invented, a molecule is invented, and if you give prolonged control of that molecule through patent law to them, public will not be benefited. That person who invented would have got his returns and he will try to dominate the whole market, and thereby for a limited duration, for 20 years, it will be given to him, provided he discloses fully. Kindly note, anybody by reading his disclosure must be able to make that product. So to that extent, with that product or process, both are there. So thereby he has an advantage for 20 years. After 20 years, anybody can manufacture and sell that. It comes to the public domain. So a person need not go on searching for the same item again and again. So we don't have to invent the wheel again and again. We can go further progressively. That is what has happened. So, but for a limited time. So then is it a property? We will try to. The property, we don't have a definition, as my friend was telling, in the GST law. But General Clauses Act, when you go, we have property of every description except immovable property classified as movable property. There, services also becomes a kind of such a thing. So that is also of no use. So applying the principle laid down by Solomon jurisprudence, I will not trouble you, because that is one of the excellent treatise on the legal things, where even I remember my professor Venkat Ram in BMS Law College taught us, even under the Indian law, IP is a movable property and hence goods. So it's a property. Three essential characteristics of a property is, now what is a property? It must be able to transfer to somebody else. It could be full transfer of the rights or partial transfer of rights other than ownership rights. When ownership rights are transferred, when ownership rights are not transferred, there lies the difference. When you have a house, when you give it for rent, you have given only utility or possession rights to somebody. When you sell off your house, you give your title of the house to somebody else. When you give the title of the house, because it is an immovable property, no GST is leviable. When you give it other than ownership, it is becomes a service. Kindly note that. That is in respect of immovable property. In respect of movable property, on the other hand, when title is cleared, it becomes sale of goods. When title is not given, it becomes a service. This is what appendix, the schedule 2 of our GST law lays down. Kindly keep it. So able to possess and own, then only it can be accompanied with interest. We will try to look in. Sir, why should we go for IPR? IPR is the real technological advancement being recognized, and it will help to speed up the creation in the human society. Sir, why you are showing this picture? Because India never thought of keeping commercial interests in its inventions. You have seen from the days of yore, we have been in the forefront of all inventions, but we have never recorded them. Probably at that time such gadgets were not available. The secondly, they were by word of mouth. Thirdly, nobody thought that their name should be there so that they get a commercial interest. But when industrialization started, when mass production started, earlier it was production by the mass, there was no much competition. But once the industrialization started, there was a huge fight for dominance of their product, exclusive sale of their products, and therefore IP law came into existence to save the industrial revolution and the goods output or that. This started such a kind of a thing. The developing nation's economy as on today, 60 to 70% is driven by intellectual property valuation. Therefore, India to grow to that level, it is inevitable we have to develop our IP in the same way so as to withstand the onslaught of developed nations. Secondly, you are aware of World Intellectual Property Organization, which is brought a uniform, trying to bring a uniformity in the enforcement of IP across the globe through TRIPS. I'll be coming to the TRIPS at the end of my talk. You have World Customs Organization, which is helping protection of IP by controlling border movement, illegal border movement of counterfeit and pirated goods. World Trade Organization is also helping hand. TRIPS is done by WTO, and therefore we need to get into that. India is a signatory for TRIPS, and therefore we have brought this into Indian laws already, because we have to come before 2005, which we have done, and so also our customs also has adopted. We will come to know one by one, but we will not look into the IP background. We will try to look into GST background. Sir, whether it is a property, then again we have to look into our constitution. Constitution, when we started the journey, property was a fundamental right. But by an amendment, we diluted the constitution, took away the property rights as a fundamental rights to a legal right under 300A, where you don't get any relief under Article 226 or Article 32. It's a negative movement, but still it was inevitable in the interest of the society during those times. So here the property defined in Article 300A includes intangible property and also intellectual property. That's what I wanted to inform you. We will spend one slide on the pre-GST. As my reverend friend was there, the fight is always there, whether it's goods or services. We have seen it in the BSNL case. We have seen in many of the cases including phone electronics, that elevator case, and it is a never-ending drama. Recently, when I spoke on works contract, I interacted on those things when how this fight was there. Now let me not. But let us take one of the circulars during that relevant time. Circular, a permanent transfer of IPR doesn't amount to rendering of service. So what is this permanent transfer of IPR? There is no word like sale of IPR, but there is a very important word which is very nearer to it. It is called assignment. So there is a licensing scheme, there is an assignment scheme. In assignment schemes, in assignment provisions, transactions, the title gets transferred, ownership gets transferred, and therefore a permanent transfer of IPR, when it happens, it amounts to sale of goods. Otherwise, it is services. In the case of Skoal breweries, the concerned tribunal also has held accordingly. Kindly read this later. There is no need to hurry. This is what is important. Who owns the property? The owner of the property, and whether it is in his name, then it's goods. When he gives it to somebody else, when he assigns to somebody else, or if he gives only the secondary rights, like utility rights, it becomes a license or whatever name you want to call, and it becomes a subsidiary right, and it becomes a service. Again, getting back, this is what I have told you. Kindly look into the picture. Property, tangible, intangible. In intangible, intellectual property comes. There are two types of varieties. One is industrial property related, where goods they are using, services are using, more focusing on the industrial outputs. So there, the criteria is originality. It should be original. And for the first time, nobody else would have done. So that's the criteria. In the copyright, their originality doesn't mean creativity. Originality is your own original expression. So it becomes slightly diluted. Copyrights and industrial rights, what are they? We will try to look in. We will try to look in a bit of patent, design, trademark, and GI in the coming slides. But the description I have given you down there, supply of services, supply of goods, kindly look. With this, you will be able to know whatever may be the rate of tax, a particular transaction, whether it is goods or services. What are the rights given? Let us make it a very short one. Whenever anybody invents a new item having new utility, novelty we call, or inventive step, there the government recognizes it, and under Patent Act 1970, it gives exclusive rights to the inventor for 20 long years, and it is called patent rights. Nobody else can use it without the owner of that particular patent permits it. He may charge you. He may assign the patent also to the companies for which he is working. There it may become sale of goods. Especially when companies are merged or taken over or diluted or sold out, liquidated, these patents also are treated like any other property. Depending upon the ownership, decisions will be taken. Another important IP is trademark. I always say trademark is the most powerful, easiest to make, and it is everlasting. Unlike others, you don't have to struggle much, but your products will be marketed with a trademark, have a difference. Without a trademark, you will have a diluted market. Why I'm telling is, I'm telling with the experience. I was speaking to Kasia. They asked us, sir, after COVID, our businesses have come down. We were the leading exporters. We were the leading sellers of these products in India. Today we are hit. I told them, what was the brand name? So we are not thought of any brand name. I said, yes, that is the problem. If you were to choose a brand name which hardly costs anything, you could have brought the customer back to you. With your quality, customer would have asked you. Today, your brand name is not there in the market. They don't know who you are. So if your brand were to be there, if name were to be there, they could have asked for the source and they could have come back to you. So if you want to really have very good market, you need to start with a trademark, and trademark is valid for 10 years once given, and it can be renewed forever and as long as you want to own it. That's the beauty of trademark. You have heard of Amul, how the trademark has been done. Today it's a world-class thing. You have seen of a lot of such brand names. Apple, people have forgotten it to be a fruit, isn't it? Let's stop there. Copyrights is for a creative, artistic works, or photography, or cinematography, or even computer programming are given on copyright. On copyrights, I have exclusive 2-3 slides later, because in GST, we have reverse charge mechanism in respect of certain copyrighted products. So I will there spend more time. I'll, for the time being, skip this part. Then you have GI, geographical indication, which shows the geographical origin of that product. In Karnataka, we are leading in GI. In Tamil Nadu, we all see the Balaji laddus. That's the internationally recently they got it. And you have hundreds of such items all over India being recognized as GI. And our Prime Minister is also promoting the GI because it belongs to the generation. It is the knowledge, traditional knowledge of the generations is being recognized. It has come from centuries, generations. It's a traditional knowledge of the people, of the place, of that quality. So that association or the group of people will own it. And for their people who are the part of that group will get that license from part B of the GI. So geographical indication, for the time being, you remember them as giving the name of the people in the background, so that like Darjeeling tea or Badigi Medicina Kai, which will be very sweet to eat. Try it. Okay. Industrial design. Design means here, it is not semiconductor design. There is another law for semiconductor design, which I don't want to go. I think with these 5, I will try to follow it up. In industrial design, it's the outward look of the product. How beautiful the product looks, that can also be recognized. That can also be protected. So, जो अच्छा दिखता है, वही बिकता है ना? So, you have to concentrate on industrial designs and protect the design so that you will withstand. There are other such legal rights given. Layout of design circuits, then plant variety protection for Plant Variety Act. That's also a kind of a traditional knowledge taken. But for traditional knowledge, we don't have any law as on today. There is a law being formulated, thought over. Still, we have to reach a finality, not reached. And we have trade secrets, which remains a secret in India. You cannot make a law. If you make a law, it will not be a trade secret. So that kind of situation we have left with. But for me, what I want you to understand is, these are all the rights given, recognized by the government. They are awarded by the government. That's what is important for me. Means if you want to get patent right, you want to get trademark right, copyright right, GI right, or industrial design right, layout design right, you have to approach the government of India concerned registry, and they will verify your application as in the stipulated form. Then they will recognize your creativity, your originality, and they will recognize your rights and they will award you. And for that, they are charging some amount. So also to continue it, to renew it for that limited period, they are collecting some more fees. There, this is the first part I am going to take the journey. The second part, once you are the owner of the patent, owner of the trademark, you have your tool ready. You can give away entire thing as an assignment as goods. or you can give it limited rights, like for Karnataka state, so and so license can be given, or particular area, depending upon that, especially in computer, you have varied varieties. So that kind of licensing, branding, franchising, what is that? I'll come to you later on. So that is what services is all about. So goods and services, both of them are available. So that is the second part. When they give, when they get the returns, so the right holders get some return for sharing their part to the public, to the person who creates goods out of it, who creates services out of it. Then the third part we have to discuss. This is what is very, very important. So whatever I have spoken, I have written here. Kindly glance through that. In this copyright, there are three types of life period available. One is for authors of the books and artistic works and other things. They can have life of the author plus 60 years. For producers and photographers and all that, from the date of publication, 60 years. For performers, it must be broadcasting rights, 25 years. Performers, I am doubtful. Kindly, I'll rectify that. Maybe 25 years, or it could be 60 years. Okay, don't worry about it. So for inventions, 20 years. Here I told you designs. You look into the shapes, patterns, and that can be even a pattern in a saree is also recognizable. A dress material or any equipment, architectural designs, they can be. Then trademark, which recognizes their reputation, brand name, they are recognized. Agricultural, natural, manufactured, attributable GI products. So these are all the things. Due to lack of time, I'll take that you have understood what intellectual property are. They are legal rights. Now, whether it is like any other property, when it is a property, can be sold. Whether IP can be sold? Yes. The patent holder can sell it, can assign it. He can rent it. Yes. Can be leased, rented. Yes. Licensed. So it is like any other property. Nature of property, no physical substance will be available. It is a legal right given to you, bundle of rights given to you. It may not be touched. Those rights cannot be touched, but it could be seen, owned. It can be owned. It can be transferable, and it can be seen in the tangible. Only when it is expressed in the tangible form, it becomes an IP valued product. So why it is done, I have already spoken to you. It is to provide incentives to virtual property. There is V missing, VIR is missing. To accord due recognition to the creators and inventors, to ensure material reward, to make available genuine original products. So you will agree with me that it is a property like any other property. It is more valuable because 60% of developed nations' income is from IP. Then you can imagine, without touching any material things, only on the mental developments, intellectual developments, they are taking a kind of a returns on that. So it can be enforced like any other thing. There is a civil, criminal, all that is available. Let's straight away move to, sir, for a particular product, can I have one or more rights? The answer is yes. Here you can see this delivery system has so much of protection, combined protection. So it's a bundle of rights. Now we will move to GST side because I have already spent 30 minutes on this. So this is what three classifications which I mentioned to you, which I have shown you in the column. I hope you are able to see it. The first part is pre-grant application you are doing. Second, it is recognized registration, licensing. You can give it for licensing. You can give it for goods and services people. It is expressed. So this is how it is done. Now I will discuss them at the time of grant. That is when it is given to you from the office, what is the expenditure till you become the owner of that product. Second, Once you are owner, when you license it or when you assign it. Second part. The third part, in goods, services, in imports and exports, and customs slight issues, we will try to understand. This is how I'm moving further. I hope all of you are able to follow. Whether it is a supply, my friend said, sir, whether it is a supply has to be, kindly look in here, both section 9 and 5.1 of the charging section. They want shall be levied a tax called central GST or SGST or IGST as per the GST Council. Their scope of supply, when you go to the definition of supply, scope of supply is not a charging section. It is defining the supply and helping you to classify them as goods and services. That's the main item. And also to have a negative list in the form of Schedule 3. That's what it's going to do majorly. Supply includes all forms of supply of goods, services, or both. Here, our IPs are goods or services or both. All of them are possible. It could be sale. Yes, this can be sold, assigned. Transferred. Yes, it can be transferred from one company to another. Bartered. Yes, it can be bartered. Exchange. Nowadays, exchange is going on full-fledged. They don't want to disclose their revenues. They don't want to collect royalty from the other. Whatever IP you are having, you give it to us, ours we will give you. Like that, they're exchanging more. Licensing, give it for similar to rental, licensing, leasing, all that is possible. It is in the course of furtherance of business and therefore it is a supply. If you go to Schedule 2, activities of transactions to be treated as supply of goods, there as temporary transfer or permitting the use or enjoyment of any IPR is given. There they have not said anything goods or services for the simple reason, in whatever way you want to argue, we will be having it. But this 5C is mostly other than assignment. When it is assignment, the other entry number my friend told, I think I must be having in my PPT, we'll call it as goods. But in both the times, it was earlier 12% and 18% difference was there, not between IP goods and services, but IP goods, IP services and network, internet related information communication technology products. There was some information thing that I'll let you know, kindly wait. So temporary transfer, permitting the use of IPR, permitting the use of enjoyment for any of this. Kindly note, we have to concentrate on exchange where valuation is a big issue. Then this was the rate till certain time, which I have given you. From 28/6/2017, it was 6%. For temporary or permanent transfer of enjoyment of IP rights in respect of information technology software, it was 9%. So information technology software is a kind of an IP programming. So there it was 9%. This difference was removed later. Now both of them are 9% only CGST. So it's 18% back rate. So nothing to worry. But here in GST, unlike other law, you cannot jump into classification of goods or services. Here you have to use the section 8 as the criteria. Once you know a transaction, keep the transaction, look into the various goods or services that are supplied along with it as a composite or a mixed supply. Thereon you have to treat it, what is the primary supply, and from that primary supply you should go, if it is a composite supply, as goods and services, or if it is mixed at the highest rate, you need to adopt. So section 8 plays a very important role. So classification of services provides temporary as well as permanent transfer. 9973 itself is going to be used because we are calling it as all of them as services. But however, 452P, any chapter, permanent transfer of IP rates is given at 18%. So there is slight confusion, but we will take it because rate of duty is same. And now 18% can be accepted. Here on development, design, programming, customization, adaptation, upgradation, enhancement, takes care of IT software. In IT software, all of you are aware of our famous Tata company case, which I don't want to deal now. Then activities to be treated as supplier goods that we have looked into, but we will try to place it with the import of services. There, import of service by a person from a related person or from any of his other establishment outside India in the course of furtherance of business, no need of consideration if supply is from a related entity. So that kindly look into those contradictions. So business class, whether business clause is also required, furtherance of this one need not be there in the imports. Even without furtherance of this one, it is there. But when it is a related person, even if there is no consideration, we have to take it as a supply of import of services. I have given an example. Mr. P Limited is a holding company in US and Q Limited a subsidiary in India. Many business operations are centralized in USA, such as accounting, ERP, and other software services for the backup, legal function, etc. For the purposes of this class, the back-end support provided by the holding company to the subsidiary company in India shall be regarded as a supply, whether or not there is a cross charge, even if the same is not recognized in the books or in the contracts, since it is categorized as an import of service by a person from a related person without consideration in the course of business, it is liable for GST. So in GST law, we have not explained, but in one of the cases, advance rulings, United Brewery case, we have called this as the IP rights. It's not of much consequence. Kindly look into that case law. This PPT, I am going to share it to you so that you can look into the concerned case laws. But I am not giving the very old case laws, which will be not relevant in the GST law. Advance rulings, no doubt, they are not legal precedents, not binding by you. It has only persuasive action. It's only believe it's a kind of a application is only between the applicant and the department. But we can take certain suggestions or something improve our thought process by using them. So I'm using only some of them. And these notifications, and this is the rate of taxes on today. This is what I have already told you. Up to 39/2021, there was a difference. Later on, all of them are synchronized at 18%. So that will take care of rate of tax. Now, really, now the problem comes to you. The first stage, everyone who thinks that he is the person who has invented or he has created or it is his works, he has to make an application to the concerned IP office. What is that IP office? I have given you the thing. You can look into these URLs. They are all Government of India, governmental departments. They are the authority who will register the rights of the people and recognize it. So application could be from the individual or from your company. Any company doing some research, they will do this application. Or somebody, some dealer wants to come out with a brand, he will apply. One of the oldest brands I know is Mangaluru Ganesha Bidigalu. During our time, he was the highest income taxpayer, a very valuable person at the time. So you can imagine that the trade name is a very popular one in India from the days of yore. But patents and all now picking up. So that is the difference. So there is a government office which charges a fee. Now we will look into only GST matters. So these offices collect an amount which involves registration fee and fee for doing certain search, certain examination, certain other activities related to the grant of rights. It may lead to grant of rights or even otherwise. But there are certain fee collected. This can be directly approached by the person who thinks that he is the owner of that intellectual property. Or he can go through professionals like patent agent, IP agent, patent attorney, advisor, trademark appraiser, or brand promoter, whatever nomenclature. If you look in each country, each place has different name. And if a new enterprise comes, he will give it some attractive name. So now the transactions that could happen is between the government department and the entity who is owning. In between them, these people are assisting them. We will call them as consultant for the time being for our understanding of the law. So consultant conveys the applicant to the government department. The applicant can directly apply or he can go through these people. When they go through these people, it is convenient for him to convince the government and get the rights because these people are professionally equipped to deal with the legal requirements of the law. So these people are techno-legal experts, we can say. So they can take care. Now, taking this, we will look into the GST provisions. This is a government service given. Government service given to an individual. Government service given to a company, IP company, or given to a professional. Then professional takes the fees, everything, including the fees that is payable, and he charges them in the invoice separately or together. All these situations need to be thought over. I hope this slide becomes meaningful only when you can realize this. I'll try to put it in simple way. Kindly wait for a second. So we have the right holder. I think it is not at all helping. Okay. Just a second. In the meanwhile, think over the aspect. We'll come back. I think my pen will be working now. Don't worry, we will not use it. We will use the picture. I have given the picture. I'll use this slide, this one, slides itself. Yeah. See now, government services we are having. What are the government services? You know, have these people. The patent office, industrial design office, trade design office, GI office, copyright office. They are the government officers. Here, application assistance could be there, or applicant can go. The office he will approach. Various IP related service providers are there. It can be IP is awarded. So now, under government services, we have any service given by the government is not exempted. If it is given to any business entity under reverse charge mechanism, tax is payable. So any amount collected by the government will not be discharged. Government will not be discharging the tax, but it has to be discharged by the applicant or the service provider who is helping him. Kindly look at the FAQ given. Are all services provided by the government or local authority are exempted? No. All services provided by the government or local authority are not exempt, except these. Suppose you have to pay services, you have to pay transport, and any service other than the services covered under 1 to the provide today a business entity, because these services are given to business entities or to a person, individual. So individual is going to make a business later. So at that time, at the applicant level, he may be an individual. So in that situation, these are liable to service tax. Don't be disappointed. I'll take you to the next slide. Kindly wait. So there, the concerned reverse charge mechanism notification I have placed here. Kindly look in. Now we will look into the second part. In that, there is one more, sir, whether they are collecting. So here is a revenue collected by that office, but it is in respect of whole of India. So not much when compared to that, but here, more of this utility is by the commercial organizations only. And whether in all respect of all that it will come or not, we will try to know. Or government or local authority are liable to pay? Yes, they are liable to pay under reverse charge mechanism. Other than this, so second emphasis is given to you. The third part, if it is for an individual up to 5,000 rupees in a financial year, it need not. There is one more benefit. If entity whose turnover is less than 20 lakhs or 10 lakhs. So the receiving entity, if it is 20 lakhs in respect of goods, 10 lakhs in respect of services, here IP rights are assigned to you, given to you, we can take it as goods. So up to 20 lakhs, you will get the exemption as an applicant. And one more thing is, if it is a registration aspect, there is one more definition. If the central government or state government, union government, by way of registration required under any law, there is exemption is given. There is no need to. Means registration for filing application for registration, it is exempted. But other than registration, whatever fee collected or taxable, there the fee favored is less than 20 lakhs, you don't have to worry. But if it is more than 20 lakhs, you need to pay. But when you go through a service provider, there it becomes slightly complicated. Kindly look into this. Here, I have tried to give the picture. IP application to government directly by the individual or the company, means the research R&D wing or the company dealing in the goods or services, they themselves apply without any middleman, without any agency helping them. Amount paid exclusively for registration, there is no GST. Whatever amount for registration fee, if you look into their schedules, they will say for registration purpose, for search purpose, for examination purpose, for PH purpose, for only search. Like that, they have different categories. In that, if it is registration, no GST. Then whatever your fee you have paid, that has to be added. And if it is this plus this exceeds 20 lakhs, then you have to pay under GST, otherwise no GST. So this is what, when you go directly, happens. I think I have made it sensible to you now. Now, when IP application to government by individual or company through consultant, slightly changes happen. So amount paid is exempted. You can't do anything with that for registration purposes. Other than that, fee paid to the government, other than the registration, plus whatever consultancy charges are there. If the consultant also is eligible for 20 lakhs, then no GST. Afterwards, they have to pay 18% under reverse charge mechanism by consultant and the chain to continue. This is what happens. Here, only in respect of large companies who are becoming consultants, they may come to picture immediately. I inquired all these agencies. They are not paying taxes under RCM, which need to be paid. Kindly examine this. I also inquired in the government departments. They also said they are not paying because it is under reverse charge. And therefore, looking into the situation today, there may be loss of revenue in this sector. I request all of you to look into this and set right. Shall I proceed to the next part? So this takes care of pre-grant. So here the ownership is given to you. Ownership is given to the IP holder. Now afterwards, that IP holder will license it or assign it. Here 18%. This is the one. This is very easy. I can move further easily. The second part is 18%. There, trademarks are assigned to somebody or licensed to somebody. That's the situation. In both the cases, it should be treated as services and goods, and 18% has to be paid. The third part, before going to the third part, we will try to look into the certain complications in this part. Here, United Brewery case, very peculiar transactions happen. As you know, other than alcohol for human consumption, GST is not leviable. Here, because of brand, there is a peculiar transactions that have happened, and they come into the GST network also. Amounts received in the nature of brand fee and reimbursement. In this case, the UB lends its brand name to contractor brewing bottling units. The brand units, they procure raw materials, they procure packaging material, they incur overheads directly to the government corporation in whole, depending on the state market. They sell that, they pay the statutory levies of state excise duties and sales tax and whatever taxes are there. Then they further account all their costs, their overheads. Then whatever profit left out, they transfer it to UB. Kindly look into this. So appellant engaged in the manufacture transfers the profits which has come at the end to the owner of the brand name, whether GST is payable. Whether beer bearing brands owned by appellant manufactured by CBI out of raw materials, packaging material of their own would be considered as supply of services, and whether GST is payable CBU on the profit earned out of such manufacturing activity, whether GST is payable by brand owner on the surplus profit. For this, the Karnataka appeal order is very clear. Activity engaged by the appellant granting CBU the right to manufacture beer bearing its brand name in return for a consideration. If he has taken for giving that brand itself in the initial stage, under that also it's a supply of service, because ownership lies here, only utility rights have been given, and it becomes a transaction and services he has to pay. And at the end, supply of service by the appellant is taxable into GST in terms of section 9 of the CGST. Service supplied by the appellant is classified under point so and so. Amounts received by the appellant from the contracting brewing units under the agreement of nature of brand free, and therefore it is also chargeable to GST. There is another one where we have to look into trademark, brand name, classifiable under so and so, whether it will come. It's a T-Post, very famous case has been delivered, and beautifully it has been delivered. To facts of the case, to make it very simple, T-Post is a very popular brand. This fellow gives his brand name also, and he has franchisee agreements also. So you need to know what is brand name and franchisee agreements. Slightly deviating from this. Trademark is the mark recognized under the Trademark Act. The brand is how this trademark is presented in the product. Then franchisee, how it is presented to the consumer, you can call it as brand. Brand is franchise in a particular way you want to deliver it. In this, you have seen, if you go to T-Post Private Limited or McDowell or so many franchisee holders, Tanishq, you know, almost all the items it is there. So there, it is a trademark used in the brand name. Later on, it is delivered in a particular way, and it is called the franchise. In all this, whatever amounts come, it could be a lump sum first and followed by monthly royalty. GST is payable on both of them. But in this particular case, the T Post has said, we want to expand our business. We ourselves will open a branch in different parts of the town, same town or same place, and we will hire the premises. We will start giving products and services to the public as our own one. Later on, if there is somebody to come, we will hand over the entire business to them, and we will collect our franchisee cost and brand cost, whether we need to pay tax. In this, detailed deliberations have been done. Kindly go through the case law, wherein they have explained what is the difference between the franchisee fee, royalty fee, and when the chest hands over the entire thing, the ownership of the building is not belonging to T Post, and therefore it is not business as a growing business is being handed over. What is handed over is the goods that are lying there. So it's a goods thing which needs to be paid, and also the franchisee to be charged as a franchisee fee. That's what the case law talks about. So, right, I've cut short because it's a very long one. So ruling is classification, franchisee fee are chargeable under all circumstances to GST. Then comes the packaging of the trade name products. You have heard of all that. I don't think now it's a forgotten time. You can undertake that you are not going to challenge, enforce the brand name, then you cannot. So that's what the issue as on today. I have given you one case law, General Mills. Kindly look into it. But for me, more important is the IPR related services, advocacy services for a patent defense or a litigation. Some advocates appointed will be having their advisory. It could be tribunals. Some disputes are there in IP. There may be arbitral tribunals services, or the brand name owners or franchisee owners, they make sponsorship services, or there is an exchange between two companies of the IPRs. That's also possible. Or during mergers, acquiring, the IPR related services will come into picture. So kindly examine this in detail before coming out. If there are any confusing issues, we will try to sort it out, because it depends upon the case of each case issues. But certainly most of them are under reverse charge mechanism. It will be liable, especially advocacy, arbitral tribunal, sponsorship. Both, all the three are under reverse charge. So you need to take care. But the other two are depending upon other facts of the case. So these are all becomes a part of the relations with the IPR. Then we will come to when these are used in goods, means when my copyright is in goods, trademark is used in my goods, or patent is used, industrial designs are used, what will happen? It will be the rate of tax of that goods, where this is also a component, because whoever takes the license would have divided that as the component to the cost of the product, and therefore this is the license fee is also a part of that goods or of that service, and therefore the entire value at which the consideration he gets from the public, that will be chargeable at the 18% of that goods rate, or if the goods are 28% at 28%, or if it is at 5% as 5%. So kindly look into these things, because if it is a cement brand, he has to pay 28% only. He will not be charging us separately, but cement, which when make it, it becomes a part of that value, so automatically it would have charged at 28, right? So trademark CGST rate at 5%, it will become in respect of goods where they are packaged and the trademark is used. Then software, whether it is goods or services, as per the CGST Act, development, design, that I have read already. If a pre-developed, pre-designed software is supplied in any medium, it need not be physical medium, storage commonly bought off the shelf or made available through use of encryption keys, the same is treated as supply of goods classifiable under 8523. Kindly note this. There is slight change. So supply of ITA service, place of supply, as my friend was telling under section 12 as well as section 13 of the IGST Act, it's always the recipient. However, if the recipient is not registered and his address is not available on the records, so second preference is records. If it is not available, the place of supply would be the location of the supplier. So this is how place of supply is determined. This Tata case, it's a very old case, kindly go through it. Sir, where are the classifications? There is a huge number of classifications which I have listed. Kindly go through them later. Now we will look into the copyright aspects, where exactly RCM is payable, liable. Here, for a literary work, dramatic work, musical work, artistic work, photographic works, cinematographic works, computer programming, who will be the owner? Who can make an application? For literary work, author. For dramatic work, the author of the dramatic works. Musical work, the composer. Artistic work, the artist who created. Photographer here in the photograph. Cinematographic, film producer. Computer programming. Sir, why these are all works and they are even computer program is a literary work? Under copyright law, literary doesn't mean it's a literature or a novel. It's a work of written thing. Even programming is also called a literary work. Then copyright infringements when it happens. If somebody makes infringing copies for sale or hire, you have seen pirated CDs, isn't it? Selling or letting. Now during cyber age, it's becoming very, very old. You can say everybody is trying to do violations, infringements, and it is very difficult to contain in the cyber age, the cut and paste age. That's what is there every moment. The copyright violations do take place. So permitting any place for the performance in the public, DJs using, you have heard of when SP Balasubramanian wanted to sing songs abroad, he had not taken the permission. So our lyricist and our music director said, no, you cannot. Right? You remember those cases? Similarly, if you are going for a DJ, the DJ had to apply for copyright license. With whom he has to apply? What is the license fee? On that, whether GST is to be paid or not, we will try to look into that aspect. For public exhibition, importation of infringing copies, registration of copyright is not essential. So it is an inherited right. But if you don't register, you have to go and prove in a court of law that you are the original writer. So it will be very difficult. It is always suggested to register your works. Plagiarism is in full mode going on. So we need to contain that. Copyright fair use doctrine is there. Fair use means certain uses, there is no copyright violations. For example, for education purposes, if I use a copyrighted work, it is not a violation. But if there is no commercial utility, and if I am using it for further publicizing that product, it's called a fair use doctrine. That's a very long talk on fair use doctrine. What are the 4 principles, tests to be done, and all that is there. I will not take you there. But there is also a concept of copy left. You have heard of open software available. For the time being, those are all copy left things where it's and you can use it without any royalty, without any copyright. But there, the condition is whatever improvisation you do, you should give back to them. So that is the one. So these are all just developments in the copyright thing where we need not struggle to levy GST on these two concepts, right? So now we will look into the reverse charge mechanism. It's a slightly difficult for you to understand. Here, the supply of services by a music composer, photographer, artist, as defined under 31A. In 31A, there is a original literary which is not covered in this entry, but dramatic musical works and artistic works are there. Don't give the normal meaning. There is a specific definition available. We will look into that definition later. I have given this PPT. So what is covered is only 13(1)A part. That is original literary. In the later schedule I am showing you. And here dramatic, musical, artistic works. There the music company which produces this music is liable instead of the supplier of services. The recipient who does that utility has to pay. Here are some complications do arise. Kindly look in. Once the rights are given, the recipients of service have to get license from the supplier of service. Before that, there is a medium organizations called registered copyright societies who are going to handle for all music composers, photographers, artists, because individually they may not be able to perform and enforce their rights. So they can assign that rights or give that assignment to the organization, to a society, so that the group of people will take care of their rights and they will collect their administrative fee, and the rest they will give back to the supplier of that service, the owner of those copyright. Such organizations are allowed. A copyright society is a registered collective administration society under Section 33. Section 34 may accept the author and other owners. For each variety, there is a formation of society possible. Working of the copyright society is under 36. So it's a legally made society. So they are having proper accounts. There was some issues pertaining to one of the copyright society, which has been set right now after 2017. Working of the copyright society is under 36. Minimum 7 members can join together, form a society, combine their rights, and they can administer it. So it's a collective administration of copyright. It is not possible for an individual author or an individual creator to fight for his rights. So this collective administration is brought. So generally only one society is registered. Sir, what are the societies available? We will try to look in. No author and the owner of the copyright of any works can keep track of all uses of others. When he becomes a member of the National Copyright Society, that society, because of its organizational facilities and strength, is able to keep a better vigil over the users, and that's how it will collect due royalties from the users, and it will give back to the authors after collecting its administrative fee. What are the societies available? Indian Performing Rights Societies. Here, this is the one which is the oldest one in India. This was the only one that was existing, but it went to some dark times. Later on, now it has been brought back to a transparent way of working. There, composers, lyricists, and publishers can collectively represent, and IPRS will give all licensing things. They will take the decision on behalf of the owners. Similarly, Indian Reprographic Rights Organization, it safeguards the authors and publishers in India. Cinephile producers, it's a new society that has been formed. It is about comprises of films producers and right holders. Recorded music performance, another one. Entity dedicated to management and licensing of public performance and radio broadcasting services. Your radio things and all will come there. Then Indian Singers Rights Association, which is very recently doing, but still it is not moved the corner, but somehow they are trying. The right of singers category performers. So what is this right of singers? Kindly note, earlier, lyricist, once it becomes a kind of a music, recorded music, the lyricist will have no credence. But under copyright law, under 2012 amendment, they have changed it. Everybody who has contributed will still hold a right to get a share of the profits, and they cannot give away their profits to the person who later on produces it. So to that extent, it has protected the singers, performers, and their rights. So therefore, these societies are available. They are working as an intermediary, as a collective bargainers of the various licenses of various categories of creators. Sir, whether we have to them, yes, we have to concentrate on them wherever it is, because they give variety of licenses. I just tried to look into the first only one society, IPRL, where they have so many types of licenses: amusement parks, arcades, hotels, internet interactive music service, karaoke service, LP, DJ, LSE, malls. For each category, so many categories they are having, different scales of tariff they are having. I'll try to show their tariff. I think I must be having it. Similarly, lot of this one should be done by each of you who are handling these things to look in what is the type of license. For example, here, tariff, essentially music in commercials and advertisements. Promo, for example, I wanted to use it in my commercial. I need to take a permission. I have to apply to IPRL. IPRL will ask this much penalty. TV commercials, this amount is taken plus GST. And out of this, after taking away all its profit, it will hand over the amount, administrative expenses, it will hand over to the owner, the remaining. So like this, for each one, there is a tariff given. So you have to be very, very careful. Applicability of the tariff, where it comes. From 1st of 2008 applies to all royalties, because it become 18%. So they have revised the year also. So this is how you need to study. There is no standard formula for a property, for a tariff, right? So now, similarly for others, you need to look in. I have told you, for the publisher of a book, original literary book, it will be the publisher. But if the author undertakes that he will pay under forward charge, the publisher need not pay. That is available in respect of the authors of the original literary work. So this is about copyright, where you should be very, very careful, very difficult to address the issues there. Then again, import of services. As my friend was telling, any service supplied by any person who is located in the non-taxable territory to any person other than the non-taxable online recipient, it is to be paid under reverse charge mechanism. Now, the one which I explained to you, I have tried to give in a lot of examples. This can be read by you later on to understand and appreciate. I have told you copyright, each definition is different. What is literary work? It includes computer programs, tables, compilations, including computer database. Means they are all not to be understood in a literal way. It has to be understood as defined in the concerned acts. Artistic work means a painting, sculpture, drawing. So you have to look in whether your item falls in. But reverse charge is not there in respect of cinematographic films and sound recording. Their forward charge is there. The authors shall pay. Then we will go to the IP on services. Import of IP services. I think Section 7(1)(b) imports, it is applicable only for service and not for goods. Goods are covered under goods, customs. So other than customs, here it comes for the service. It should be import of service as per section 211, where the supplier service in India, supplier of service should be outside India, recipient should be in India, and place of supply should be in India. Kindly look in. The place of supply is in India. The example which I gave you, there the supply is in India. Services shall be provided with consideration. Services may be in the course of furtherance of business or not in the furtherance of business, but under entry 4 of schedule 1, even if there is no consideration, if it is through a related person, tax GST is leviable. So import of services, it's a supply liable to tax is understood by these legal provisions. We will look through certain frequently asked questions. Will import of service without consideration be taxable under GST? As a general principle, import of service without consideration will not be considered as supply under GST under 7. However, import of services by a taxable person from a related person or from any of his establishments outside India in the course and furtherance of business, even without consideration, will be treated as number 4 because of the provisions which I explained to you. Another one, how will imports be valued? As per the proviso section 5(1) of the IGST Act, customs law will be applicable for valuation of goods. So goods at the time of importation, when presented to customs, if it is already having the brand name and the cost, royalty, everything is there, that will be the value for that purpose. There is no need to add royalty again in the domestic area, in the GST area. But if it is not at the time of transportation, then it may be liable if it is something happening later. That is in respect of goods. But in respect of services, however, for valuation of import of services, section 15 of the CGST Act, it is not customs law, it is the CGST Act we need to take. So there we may have to go for the generally accepted audit procedures. As per that, we need to take. There are different procedures available. I think some of the CS we are sitting here will be able to highlight them later. Place of supply is the location of the recipient of the services. Import of services, if the recipient is not registered person, then OIDAR services will be there. OIDARs is always service, but in OIDAR a special category has come now. There, OIDAR service, which is not merely a game, but where it is an online money gaming, it is treated as goods. So online money gaming, there is a separate provision given under section 14A of the IGST Act. There they are treated as goods and they will be chargeable as actionable claims, specified actionable claims. For example, the changes that have happened at 28%. So there you have casinos, online money gaming from GST Council's 50th and 51st GST Council things. I have written 2-3 articles on this. Kindly go through them in the All India Federation Tax. There also I have written, even Puliani I have written, and other leading people, this way, since I have written. Kindly look into them. It's a very important development in GST law where we changed the actionable claims into a different kind of thing where we have online money gaming, even if it is given by a person, supplier outside to an unspecified person here, for an unspecified, unregistered man, it becomes payable as goods. But here, though it is goods, customs will not collect, GST office will collect. So there, in the proviso to section 5 of the IGST Act, we have made the change for this purpose. Whether transfer and possession necessary for a transaction constitute a supply of goods. Kindly note, wherever we say goods, there must be transfer of title as well as possession. Then only it is goods, or not otherwise. Whether transfer of right to use goods will be treated if it is for future, when it is going to be transferred, even that time it will be treated as goods. So this is what Schedule 2 talks about. Then as per Customs Act, this is very interesting. This is what my friend also quoted. Kindly look in. I've given it through a FAQ so that everyone can understand. Royalty and license fee are included in the assessable value of the goods. Whether GST is also payable on such royalty and license fee, which is already included in the value of the goods, the answer is no. Right? If it is not included, then yes. There is a case law also in this regard. I'll come to that later. Then another FAQ. I'm an Indian company who makes software, sells it outside the country. I have hired a firm, not a related party, abroad to facilitate the supply of software in Europe and US. Would I be liable to GST on the payment of that I make to the entity abroad? The answer is making a bill directly to the clients, not to the agent, and therefore there is no GST liability. Similarly, here, I am an agent in India of a foreign ITS service provider. For agency service, I bill the principal in convertible foreign exchange, whether GST is liable. You are an intermediary and the place of supply is, the principal is in India, irrespective of the mode of payment, hence GST is payable. So these kindly look into these two situations, which are very clear. Then exports to be part of the value. Similarly, custom valuation, it is to be added, because if you look into the customs law, Rule 10, read with Section 14 of the Customs Act, clearly says what are the things to be included: engineering, development, artwork, design work, plan, royalty, license fee. All these expenditures were pre-import expenditures, and it is already embedded. If it is a software, it should be embedded, or royalty is already paid. Royalty is of that machine is discharged, then there is included in the customs value, and therefore further GST will not come. But if it is not a pre-import, if it is post-export, of the goods are cleared by the customs, all those activities are taking place, then it should be subjected to IGST whenever it is transactions are done. I think with that, I'll come to the last part of my talk, where IP rights, as you know, in India, we have movement of counterfeit goods and piracy goods, means people in violation of the IP law, without taking the permissions or taking the license or not paying the royalty, doing transactions in a fraudulent way within India, it is enforced by the various enforcement agencies, including police. We will not look into that. But for cross-border, there was no such protection available. So in the Treaty of Trade-related aspects of WTO, they came out with border enforcement measures. In the Article 51 to 60, wherever any goods enter a country, they have to be looked into whether they are pirated or counterfeit. To enable the customs to know, the right holders are asked to register with customs. So we are expecting certain pirated goods or counterfeit goods coming from the ports. So these are all my original things, and they have to pay a fee, and they have to online enter arts, we call that's the software being used. And from there, they should see that they register their copyrights, trademarks, geographical indications awarded already by Government of India on payment of certain fee of 2,000 rupees with the department. And once they register with us, the commissioner will, in the IP cell, will fix the bond and bank guarantee to be paid, so that when those goods come to take care of any damages that may occur, later on, he will recognize it. Once it is registered, it will be notified for all the ports. So as soon as goods, such pirated goods, enter India, the concerned right holder will be notified. He will join the proceedings and further proceedings will be taken to protect his rights. This was started with TRIPS Enforcement Rules 2007, wherein I also started my IPR journey. That's what I told you. TRIPS talks about only two rights, that is for trademark and copyright. But we, in an enthusiastic way, went for patents, designs, and GIs. Patents cannot be recognized by the customs at the time of import. For example, this mobile phone contains more than 5,000 patents. How can I recognize? It is impossible. But designs and geographical are prima facie noticeable. Therefore, patents were removed. Now it is limited to designs, GI, trademark, and copyright. So they are given protection under customs law. This is what customs enforcement rules. Here, even customs law from the beginning provides for it, but we are not able to. We have the authority to go for suo motu action for counterfeit and pirated goods. You can look in section 11, prohibition. In that, section 11(2)(n) talks about this. Protection of patents, trademarks, copyright, designs, and GI. It also speaks of prevention of contravention of any law for the time being enforced. And therefore, customs have powers because we were not enforcing regularly. It is not possible for the customs to know who is the owner of each of the IPs. This has been devised by TRIPS and we are implementing it. And in the days to come, it is very, very tough ahead. I always speak in the cyber age, the IP rates become totally diluted. It is impossible with the present law to protect the rights. We need to think of this because we are moving from physical space to the non-physical state where machine itself takes the decision and physical inclusion is almost physical. This one is excluded, you can say, in the industry 4.0, where we have Internet of Things, cloud computing, big data analytics, 3D printing, which is already there, blockchain system. Here in a digital enterprise, there will be no need of any physical presence. The machine itself will learn and start doing it. It will start delivering it. At that time, there are a lot of copyright issues, IP right issues. Even in the granting itself, to whom it should be granted is also still to be decided. So in the days ahead, we have tough times. So this is what I feel. You have listened to me with a patience and a lot of people have helped me to come to this conclusion. I thank you. Now I open up for question and answer session. I think it's a bit long. Last time I spoke for 2 full sessions, but here for industry, we cannot ask you to spare so much time. So they have limited it. And to the best of my ability, I try to give. If there is any further issues, please try to ask me. If to the best of my knowledge, I'll try to answer you. Thank you. May God bless every one of you.
Thank you, sir, for the wonderful and detailed presentation, which brought a lot of clarity to the topic. The presentation threw a lot of light on the subject and clarified a lot of doubts. Now we move on to the question and answer section. Sir, we have prepared some questions which we received in the PowerPoint. Just we will share it now, sir.
Yeah. Don't ask me complicated question there. I may fail the examination. Please go ahead.
So the first question is on the screen, sir.
Yeah. Company A owns trademark and transfers the registered trademark to B permanently for use in the notified territory. Transfer of restricted by territory. Whether this is a transfer of supply, it's only a service. It is not assignment. It is not goods. It's a service. Whether this transfer is a supply, the answer is yes. 18% is to be given on the consideration charged by A.
Second question, sir.
Yeah. Sir, I work under the framework franchisee model. Whether the royalty I pay is to be classified under as a, you don't have to do. if you are working under a IPR, when you are making payment, the supplier of that franchisee agreement, that person will collect it from you. So when you are selling your goods, you would have naturally included to the cost of your product. You are a recipient of this franchisee model. I hope I am correct. So there, if you are not the owner of the franchisee, if you are borrowing because you are working under a franchisee model, you are paying money to him, royalty to him, he will raise the invoice, you are paying him and he has to account. You should see that he accounts it. And once you make payment, you can use it as an input tax credit on your further business. Is it clear? I have included the value of royalty and license fee in the customs value of the goods on import. Whether I am liable to pay IGST on the value of the royalty and license fee separately, the answer is no. But there are two types you should try to think. If you bring a machinery, on that machinery, if you have paid the royalty and the license fee, it need not be. But for the products that come out, still the question largely answers, whenever you bring out a product, on that also, if you are paying royalty later, at that time you have to pay for that later amounts, IGSTs at appropriate time, not otherwise. So there, I think last time I have discussed one case law pertaining to Chennai, which I missed this time because of the limited time, where it is decided certain amount taken, it need not be paid because it has no influence after the goods have been coming. There is no change in whether it is royalties there or not, the price of the equipment is same and therefore it need not be included. Such case law is there, kindly look into that. But here, if at the time of importation, the royalty license fee which you have paid is already covered, there is no need of paying any IGST here because it has already become cost to you. And IGST paid by you would have again gets that customs. This one will be a component of it. Next. Sir, please clarify. I paid an amount as goodwill while acquiring a business. Whether tax is to be paid on this? The answer is yes. You have to pay GST on this. It need not be a trademark. Even on goodwill, you have to pay. It's a service. We are manufacturers and exporters of agrochemicals. Manufacturers and exporters. In connection with manufacturing of one of our products, we intend to import process technology to improve the yield of finished goods with the reduced process and production time. The technology is normally imported in electronic form with an option to get printed copy by courier. Please let us know the tax implication. It is treated as import of services. I have given the example here. You have to discharge the GST part on this, IGST part. On services like this, there is no customs duty. Next. Sir, whether publishing of a commentary video on a piece of copyrighted music qualifies as a transformative under the fair use doctrine. It is not a fair use, it is an unfair use doctrine. It is to be, permission should be taken. You should pay the owner's permission, you should take, you should pay royalty also. So it is not a fair use doctrine because you are commercially exploiting it. So it is not a fair use, right? Always the 4 test is important. If it is commercial, it doesn't allow you a fair use doctrine, right? You are making money out of it. Any other question?
Thank you, sir. I find no more questions.
I think I have passed the examination.
So we come to the vote of thanks part.
Nice.
I take this opportunity to thank our Additional Director General Shri Rajiv Ranjan sir for his valuable guidance in continuing this webinar. I also thank Shri Sumit Kedia, Mrs. C.A.B. Geeta Madam, Mr. Ramakrishna Sangu, and Mr. G. Bhaskar for their continuous support to our Chennai unit. I am very grateful to you, sir, Shri M.G. Gauraram, sir, for immediately accepting our invitation and for delivering a very detailed presentation today. I also express my sincere thanks to all the participants of today's program. Thank you, sir.
Thank you.
We come back to
Sarve
the-
janaha sukhino bhavantu.
Thank you, sir.